Hey friends, criminal defense attorney Ryan Pacyga, and today I'm going to share with you a result in a case, and I'm going to let you know A, how to sometimes work around a charge of felony threats of violence in Minnesota and avoid that conviction. B, how to also potentially avoid a conviction or even a trial on a second degree assault with a firearm, which can get you a 3-year mandatory minimum prison sentence in Minnesota. And C, talk about how we saved a medical doctor's career and potentially other outcomes for him and his family. So, this is a little story here. The case all starts on a summer day in Minnesota where my client, who's a medical doctor, was home with his children. It was during the pandemic. And the kids start making noise out in the yard, and it's a pretty big yard they live in, like the 75 yards at least from the house to the tree line where the next property is, right? All right, so kids start making some noise. Some neighbors call 911 complaining about the noise, kind of a non-emergency thing, but they call 911 anyway. So it's ticking a few neighbors off, right? Well, one of the almost adults, she was like 17-year-old daughter of one of the neighbors, starts swearing at my client, and so he swears back. Well, this ticks off the father of this almost adult female daughter neighbor, right? Dad gets really mad that this guy talked to his daughter this way and runs through the tree line and starts swearing at my client and his kids and perhaps threatening them as well, saying things like, I'll kill you or something like that. At any rate, so the client's kids run into the house, and Dad, the client, locks the screen door real fast, or the sliding door. This doesn't stop angry neighbor guy. So angry neighbor guy keeps coming towards the house and yelling, and now unlatches a fence gate that's really close to the client's actual house, well onto the property now, probably 75 yards onto it, and is yelling things. Now this scares client at this point in time, so he grabs a shotgun out of the closet, and the neighbor guy and his daughter allege that client pointed the gun at them. But the defense was self-defense and defense of others, indicating, in fact, our client told the 911 operator that he did indeed brandish the shotgun, but he had not actually pointed at them or threatened them with it. He rather tried to do that to dissuade them from breaking into the house or something like that, because he was scared. In fact, while the neighbors called 911 and another neighbor said they saw a point, there was a big, if this case would have went to trial, there would have been a big debate on whether he really pointed the gun at these people versus simply brandishing it and saying, get off my property and leave us alone. In fact, client even called 911, and during the 911 call, it said, I pulled the gun out. I didn't point it at him. I left it pointed at the ground, but I told him to get away because I was scared. Of course, neighbor guy says, oh, he pointed it right at us. So does neighbor guy's daughter, right? So there's the debate. Who's a jury going to believe or not? Are they going to believe it was self-defense and that the gun wasn't pointed, or that it was reasonable to brandish the gun, or was the jury's going to say either you pointed it, or even if you just brandished it, that's too far or something like that. So you never know how a jury's going to deal with that. It would have been, I think, an interesting case to take to trial. But here was the hook. Client's a medical doctor. Okay, I've represented doctors in the past, and if doctors have any sort of assaultive conduct, it often precludes them or bars them from doing direct patient care anymore, and perhaps you could even lose your medical license. Certainly some hospitals won't bring you on to continue working there. So his livelihood was at stake as well, right? So he had a different lawyer originally, and he was charged with threats of violence. And my understanding of their plea negotiations were that if he didn't plead guilty to felony threats of violence and admit that he threatened someone to terrorize them, which would have cost him his medical license most likely, then they were going to amend the charges to a second-degree assault with a firearm, which carries a 3-year mandatory minimum prison sentence in Minnesota, all right? And this is where it went. Well, for reasons that won't be discussed on the video, that lawyer was removed from the case, and I got hired to be asked to take the case over. He was referred over to me by his brother, who was a public defender. So I get the case, and I went out to the scene. I visited that. I spent time with my client. I wanted to get the lay of the land. It's always important for a lawyer, in most cases, to go out to the actual scene to appreciate what it feels like to be there. You notice things that you just don't notice by reviewing the evidence on paper. So I think it's more often than not, a lot of times, most of the time, I'll go out to the scene so I can get a feel for what's going on in the case. It helps me do a better job for the client in trial, in a motion to dismiss, or even in negotiations, whatever we can do to help in the case. At any rate, I got a really good feel for that, and we determined that he wasn't going to be pleading guilty to threats of violence, that he had a viable self-defense or defense of others claim, and I filed that notice there, all right? Well, of course, you never quite know what a jury's going to do, and that's the reason I'm sitting in this corner here to display. We've got, the one hand, this is a gray area of a case. It could go that way or that way. Is a jury going to say, no way, this was over the top? Are they going to believe he pointed the gun? Because some people are saying he pointed it, some people aren't. So who knows which way they're going to believe that? Or are they going to find that he acted reasonably in self-defense or not? Or was it over the top? So with all of that, he didn't want to risk that, but we were going to go to trial and not take a felony or any kind of conviction that would cost him his career. Well, lo and behold, we end up negotiating to the point where he gets an offer that he wants to take for a misdemeanor, reckless handling of a firearm. It's not an assault at all. It's a misdemeanor, not a felony. Didn't have to do any jail time. And the good thing is he's going to be able to keep his medical license. He's going to be able to keep his job at the hospital. And he's not going to have to do any jail time. And he's not going to have a felony on his record. All right, and so all of these things are very important. Ultimately, it's always a client's decision about whether you want to take an offer or go to trial. I was ready to go to trial for him, and we were going to do that. But once he got an offer for a misdemeanor that was not an assault-based thing, knowing that you never know what's going to happen with a jury or which side of the story they're going to believe, he made the decision. He was so happy with that offer that he took that. And I think that's another thing for people to know. A lawyer should never pressure someone into pleading guilty or going to trial. We can certainly let you know what our experience says about whether your case is good for trial or not, or whether an offer is a good offer or not, certainly. But I don't believe in forcing someone to go to trial or forcing someone to plead guilty or anything like that. These are, we work for you. You don't work for the lawyer. And so the lawyer should certainly guide you, give you advice, tell you what our experience says. But at the end, it's always the client's decision, and we should honor that and respect that because it's the client's life, not ours, right? And so as long as for the lawyer in me, would have loved to have gone to trial in this case. These are interesting cases to try. I love trying self-defense cases. Cases where there's diverging sets of facts, which is when cases usually end up in trial. One group of people say it happened this way, one group of people say it happened this way, and who knows what a jury's going to believe. But nonetheless, it's not about what's fun for the lawyer or not. Yeah, it would have been a fun case as a lawyer to try. But our job is to serve the client and to get the best outcome available to them and to do their wishes. And so I'm confident that we got the best offer that would come that was not made to the other lawyer when he had a different lawyer in the case. And it was something that the client was very happy with and wanted to take. And ultimately, it's what's best for the client, not what's best for the lawyer. So we always have to keep that in mind. So who knows what a jury would have done. It would have been fun. But I'm happy to report that the client was able to save his career, save his earning capacity for his family, continue to practice medicine and give good care to people, and will not be bootstrapped with a felony conviction on his record, will not have to go to prison, and all of those good things that happen with that. So that's a misdemeanor. The statute, by the way, if you want to know what it is, a dangerous weapon, handling of a dangerous weapon basically is Minnesota Statute 609.66, and subdivision 1A1 is the misdemeanor portion of that. And what a great creative resolution that was, to eliminate risk for both sides and come up with an outcome that the client was very happy with. which was another benefit, I think, of having a lawyer with experience in cases. One that the prosecutors know, hey, this defense lawyer knows how to try a case. They know how to convince juries and show them what's important. No lawyer is going to win them all, but if you got a good lawyer that tries a lot of cases, I think it makes people think about what kind of offers they're willing to make on cases. The client knew that I was in his corner and had spent the time going through the scene, sending our investigator out to interview witnesses, and developing our defense theme of the case as well. So that all came out to be a good resolution that the client and his family were happy with. If you have any more questions, I'm criminal defense attorney Ryan Pacyga. You can find me at arrestedmn.com or at 612-339-5844.